Well, it's a great pleasure to present the second of our IISTL webinars. Today we're going to be looking at contemporary issues in energy and maritime law. I'm Simon Bourne. I shall be chairing today's panel discussion, which have got some very topical presentations. The first presentation will be from Dr. Tabitha Shepherd, which will be about the impact of the COVID-19 pandemic on oil and gas contracts. And I think we might hear the word force majeure mentioned at some stage. Moving on to our second presentation, Dr. Leah Amaxilati will be discussing the impact of COVID-19 on seafarers. Seafarers are very much the unsung key workers of this pandemic, getting goods and food to us in our lockdown situations in our various countries, whether that be England or Wales or elsewhere. And I think they're having a bit of a rough time of it. Leah will be expounding about those issues. And then, not really directly related to COVID, but something which is incredibly topical and important is Dr. Yuri van Lopten, Cargo Ships of the Future and the Law of the Sea Convention. How do uncrewed ships, unmanned ships, which are going to be the future, so they say, how do they fit in to the Law of the Sea Convention? And I'm sure Yuri will be giving us some quite provocative thoughts on that, which I think I can safely say are perhaps a bit out of the mainstream of what people have assumed about this. So now, hold on, I need to find the button which I'm going to do a promotion now. We are very pleased that we are holding our 16th annual colloquium in September, 10th and 11th of September 2020. It's going to be an online colloquium because the pandemic really doesn't give us the opportunity to do our conventional in-person one. It's going to be on the 10th and 11th of September 2020, and it is disruptive technologies, climate change, and shipping. And the disruptive technologies part is going to be on the 10th of September, and then the climate change aspects are going to be on the 11th of September. And we've got a very interesting lineup of speakers and topics, and do hope to see many of you there on the 10th and the 11th of September in our virtual colloquium. So, having said my introductions, I will now hand over to Dr. Tabitha Shepherd, and I will mute myself. Now, one last thing. If you've got questions, that's great. We'll be taking questions at the end. I will look through the Q&A thing for your questions, and I will then present them to the panelists. So if you've got questions you would like to ask, just type them into the Q&A section, and I can monitor that. Tabitha, it's all yours now. I shall monitor I shall mute myself, and off you go.
Thank you. Okay, before we actually start, I suppose I should say that I am aware of the fact that I only have 20 minutes to speak. And anybody that knows me knows I have a bit of a timekeeping issue. I don't think that's an unknown fact about myself. But I found one of the biggest struggles when it came to preparing these slides was trying to fit in some of the potential major issues of discussion into a 20-minute conversation, or at least a monologue, if I can put it in unkind terms. So what I hope to do is I'll focus on about 2 or 3 areas and give a sort of snippet, a sort of overview of discussion, and just generally ask some questions. And hopefully give you guys something to consider when you're looking at oil and gas contracts within the context of COVID-19 and just being aware of these potential issues. Mostly because the truth of the matter is, when it comes to the oil and gas situation, I mean, if anyone has been watching the news, you're aware of the fact that this is probably one of the most affected markets globally when it comes to what's happened with the global pandemic. But not a huge amount of it is sort of legally based. This is more about issues of humanity, of negotiation, of economics and politics. The sort of legal issues are probably going to arise later on, and it's not about innovative or new or uncharted territory in the same way, for example, than unmanned ships might incorporate. It's about looking back at legal issues that have existed for a long time, or legal issues that haven't really been touched or used or considered very often, possibly coming to the forefront again, and how that works within the interplay of the global context, global economy, and politics. So really, I have 20 minutes. I keep repeating this because it's stressing me out that I have so little time to talk about these issues, because I could probably go on for hours and hours about them. But I wanted to focus on a few small areas just as a general introduction. And if Simon, if you could be so kind as to move on to our first slide. So issues I wanted to talk about generally is I wanted to mention disruptions of operations, because that's probably the biggest area of contention. It's the area that the majority of lawyers are going to see cases about. They're going to be dealing with clients on these particular issues and things that arise as a result of disruption. And the natural consequence is that if you cannot solve your problems amicably, then you're going to be trying to get out of the contract. Most of these contracts are long-term, so you're going to be looking at your force majeure clauses. I'm not going to go into a lot of detail about this, because I don't want to repeat anything that Professor Tettenborn might have done in the first webinar. To be honest, when you have someone like Professor Tettenborn talking about force majeure, there's nothing really that I can add to the conversation that he hasn't already said. Then I want to look very briefly at the idea of creditworthiness and defaulting. So mostly on the financial side, when it comes to oil and gas, one of the biggest areas of law is not actually about, getting the oil out of the ground. It's not about exploration or exploitation. I mean, that's the fun stuff, but it's really about the financial side, the obtaining your investment in the first place and how you're going to manage that. So I just want to look very, very quickly at those two issues, and then move on a little bit into mergers and acquisitions, because that's also one of the secret big areas of oil and gas. So starting quickly, should we go to the first actual substantive slide, Simon? Thanks. So when we talk about disruption of operations, I'm guessing for the majority of people, when you think about this, you're thinking mostly in terms of staff. You're thinking in terms of human beings, because COVID-19 obviously is a virus. It affects humans in medically, physically, and puts them out of work. It puts us in situations economically and politically that causes all sorts of other problems. But at heart, it's a human issue. And that's entirely correct. It is one of the big sources of disruption in a lot of operations. Purely I think I've narrowed it down to about 3 big reasons. One, the actual people who are working either as employees of the operator or within the joint venture, or for example, in third-party contractors, they are physically just getting sick from the virus and thus have been taken out of the playing field. They're not working, they're not doing anything, and sometimes you'll have medical costs, expatriation costs, all the sort of standard other issues that the company will have to take on when they're dealing with a sick member of staff. So that can be one area of disruption. Not to be cruel about it, but if you have your kind of skilled manual laborers working, I won't say that they're relatively easy to replace, but you're going to have backups. You're going to have people on rotas who will be able to replace them while they're sick. So that is obviously a tragic issue, but it's not one of the biggest areas of disruption. When you start to get disruptions is when you go higher along the chain of command, or your sort of hierarchical structure within the company. If you're having your sort of line managers, your experts, your technicians, your specialized engineers, people that are not as easy to replace with other members, if you see what I mean. You can't just swap them in. So those are sort of secret areas of disruption that you might find if somebody in particular is sick, a key particular member of your group, your operations, then you can't progress further without either their permission or their expertise. So that is one potential area. The other is the fact that there are travel restrictions. As a result of a lot of the lockdowns, you have quarantine restrictions put into place. You have members who might have been sick and want to come back into work, but physically just cannot make the journey because either they're blocked due to unavailability of transport, planes aren't flying, or there's quarantining restrictions, and a lot of these other similar issues. In attempts to be sort of prudent operators, in attempts to be safe, especially at the beginning of the pandemic, when not a lot was known as to how serious the virus was, how spreadable it was, how deadly it was, some oil and gas companies even chose to tell a lot of their members of staff to go home. You can work from home in the same way that many of us do. Now, in the United Kingdom, at least, oil and gas workers are considered key workers. So a lot of the key worker rules did not apply to them, and they didn't have the same sort of liberty to work flexibly as the majority of other members does. But that wasn't the case all over the world. So you would have had, and we did have, a lot of companies telling their workers, go home and work from home, which was fine, or at least to take their vacation time. But now you have that issue that they just physically, whether they're healthy or they were sick and now they're healthy again, cannot make it back. So you have that issue where if you don't already have members of staff there in these sorts of isolated locations where a lot of these projects take place, you have a deficit in your staff numbers. There's physically either people who are not working because they can't get there, or you are stuck with people who are there on rota and they're now taking on double shifts, which causes problems in its own right. I mean, it's difficult enough, for example, if you're in off the coast of Kazakhstan, in sort of like a big camp area where you sort of set up these pods where you'll have groups of people, projects, sort of mini projects within your overall venture working and not interacting with others, and they'll build areas of isolation. But when you're dealing with offshore issues as big as you can imagine a rig can be, when it comes to something like the spreading of the virus, obviously now you're in a very tight, small location, and you don't have a lot of space to move. You can't really be outdoors. So the spreadability is also a big issue there. So you've got sick workers or potentially sick workers who can't move. You don't have relief coming in. And these are going to be issues that Dr. Maxalati will be talking about in more detail. So you have those kind of problems there as well. And the other point, the final point I want to mention when it comes to staff disruption is the fact that you have health and safety requirements, health, safety, and environmental, especially if you're working in countries that have stringent sort of rules on this anyway, like, for example, the United Kingdom. It's very difficult. I know here, when I talk to friends who are working in companies and small, tight space, it's difficult to sort of organize how this might happen, how you might put yourselves together in that sort of situation and work effectively. But when it comes to offshore oil and gas and you're stuck on a ship or you're stuck on a rig, sometimes it's just completely impossible. But even so, staff disruption is one of the things that you might consider first and forefront. But in actual fact, it's one of those things that will eventually be worked out purely for the fact that there are always more people. And restrictions, especially now in the later months, are relaxing somewhat. One of the key areas of sort of disruption that's probably going to take place, not just after the virus has calmed down and things are getting better, but has already started to happen anyway, is disruptions along your supply chain. So this is one of the things that not a lot of people might have considered. When we talk about oil and gas and the crisis currently that's going on, we're talking about the fact that there's too much oil, that there has been an influx, there's a glut going on. You would have heard a few months back that in the United States, there was actually oil prices dipped so low they were in the negative. So you had producers actually paying buyers to take the oil off of their hands. But what you might find, and what we're finding now, especially now that all the cuts and the global issues are slowly being resolved and the economy is coming back into work and the demand is increasing, is that you're going to have knock-on effects when it comes to your supply chain. And I'm not talking about actually producing the oil, but obtaining the equipment, obtaining your staff members, obtaining specialist technology that might not be produced or has been slowed down as a result of the lockdown or direct consequences of COVID-19. Now, what do you do in that kind of situation as a producer? I mean, one possible option is to literally sort of go to your supplier and say, look, I need this equipment. I need it badly. Here's a ton of money that I would have paid you in a few months or in installments. Take it now. Or what a lot of companies, if they can afford to do so, are going to their suppliers and either acquiring them directly so that they have a more direct chain, or they are basically giving them money and saying, look, you can pay me back later. Here, give me the equipment now. Alternatives also include, for example, resourcing the supply. But if you are trying to resource supplies in an oil and gas industry, it's relatively simple if you're looking for things like core materials, like raw materials like steel or concrete, things like that. But once you're building really technical equipment, once you're in the middle of constructing that pipeline or that facility, I mean, things become much more difficult in order to try and resupply. So that's an area that you're just physically sometimes, you're not frustrated in the legal sense, although that is equally possible, but it's just if you're not able to obtain your materials from your supply chain, it's stalling you. So it's not always just the producer's fault. Now, the other problem when it comes to disruption of operations is the fact that it's economically unviable to do so. Now, this was a big problem in the United States in particular, where you had operation costs that are much higher than a lot of places around the world. Simply because obviously it's the United States. And in addition, in that particular market, they took on a lot of debt in order to start facilitating this major increase in oil and gas production when shale oil began to grow and was developed as a sort of source of oil and gas for the United States. So you basically are finding in those sorts of situations, because there is a glut in oil, because the demand has been quite low, that these companies' operations generally are very, very expensive. So they're finding that maintenance of products, operations, and the cost of doing so was much, much higher than the income they were receiving, either because the oil that they were selling at prices were so low, or simply there just wasn't even a demand, even for the oil being that low. Now you could say, okay, that's probably fine. You kind of produce the oil and then you're going to sell it later on. And that's actually what saved a lot of companies when it comes to their debt financing issues. And I'll talk about that in a second. But part of the other issue is that because there has been so much oil produced, and because the sort of cuts that OPEC Plus and the agreements that a lot of interstates have made between each other have only started really to take in effect, there's this surplus of oil that's basically just been sloshing around in countries, and there's nowhere to store it. So it's not just that producing the oil and maintaining the operations is expensive, but it was basically meaning that these companies, a lot of these companies, especially in the States, were finding it almost impossible to store it anyway. So the reason why I want to talk about all of these issues here is because that is what leads into my slides on the reasonably prudent operator. So Simon, could I move on? Now, the reason why I wanted to talk and sort of give you all this overall context is because all of these things are basically what is probably going to lead into one of the biggest issues that's going to arise in the oil and gas industry. Now, there hasn't been a huge amount of force majeure clauses that have come into play yet. There, of course, have been some that have started to arise. But we're starting to think that because the economy is getting back on its feet, because the demand for oil is increasing, that things are going to get better, the rates are recovering, everything is going to go back to normal. When in actual fact, it's more than likely going to be a delay in a lot of legal action. Companies that have been struggling to maintain or stay afloat during the crisis itself are probably going to find that they're not going to be able to maintain things as time has gone on. They've also engaged in long-term contracts that are going to be affected later on when sort of things hit the fan, if I can put it in that respect. They're going to say that they would have negotiated with their financial lenders, they would have negotiated already with their suppliers, they would have negotiated with their buyers to give them some leeway. But now, as time has gone on, it's going to be probably more economically difficult for a lot, especially to the medium and smaller sized companies. So you're probably going to end up in a situation where either buyers or potentially even the supplier who's found himself now in a terrible deal that he's not going to be able to cope with the low prices and want to renegotiate and is unable to do so, invoking the force majeure clause. Like I said, Professor Tettenborn talked about that in some detail, but there might be knock-on effects as to how well those can be evoked within the context of oil and gas. When we talk about what happened in the actual peak of the COVID-19 situation. The reason why I bring this into play is because in oil and gas contracts, it's relatively typical to find in the force majeure clause itself, express reference to reasonably prudent operators. So before you can invoke your force majeure clause, you have to actually have this express requirement that you were reasonably prudent as an operator before trying to invoke the clause. So what will normally happen is, one, you'll have the difficulties of trying to invoke the clause anyway, which I'll talk about in just a second. But two, the big issue is when you were dealing with the actual crisis at the time, were you being reasonably prudent? What exactly that means is a big area of contention, or it will be, because it hasn't actually had a lot of judicial guidance. One of the big cases that discussed it relatively recently was the Scottish Power BP exploration case in 2015. And even there, they were talking about the reasonably prudent operator within the context of their contractual obligations. The big question now is, well, when it comes to health and safety, are they required to be reasonably prudent? So when you're looking at invoking the force majeure clause, and they look back and said, well, during the actual peak of the crisis, did you handle this in the correct way? The question is going to come, well, did they actually do so when they sent, for example, their members home? When you had difficulty changing over the crewmen on the ship, where you couldn't physically get them there, so you asked the crew on board to actually do more than they were reasonably or contractually obliged to do. Were you acting as the reasonably prudent operator? And that's going to be something that I think a lot of people are going to be wanting to discuss. The other side to that is this idea of having good oil field practice. Now, that is a term that's been thrown around the oil and gas industry since the oil and gas industry has existed. And what exactly that means will depend entirely on usually the facts of that particular case, the context in which it's written, and of course, within the contract that it's written in itself. The fact that it could be an implied term into your contract will also depend on the context and the choice of law and which the operation takes place. So how am I doing for time, Simon? Am I going overboard?
Tabitha, we've got 3 minutes.
Perfect, actually, because this was my big area of discussion. If we could move on to the next slide, though, on force majeure. Here, as I said, Professor Tettenborn talked about it already, so I'm not going to go into a huge amount of detail, but the one thing I will say is, of course, if you've got an English contract, if you're operating under English law, a force majeure term has to be incorporated expressly into your contract in order for it to be invoked in the first place. But then there are some questions I'd like to ask, in particular for when you're dealing with oil and gas, and that's, first of all, do you have to identify the specific measures, the specific things that have occurred within your sort of crisis that that have resulted in your ability to invoke the clause. And by that, I mean, if you sort of say, well, there was a corona pandemic, everyone got sick and things became much more difficult for us overall, you're probably not going to have identified a measure specific enough to have successfully invoked the clause. You're also going to have had to have tried to mitigate the impact of the measures. And when you're talking about this, it goes back to that issue of the reasonably prudent operator. Now, there is an implied requirement, of course, under English law that you have to operate under reasonable care and skill. How that marries up to being a prudent operator, how that marries up to good oil field practice is something I think that's going to be discussed heavily later on as you start to see these issues really coming through. The other big thing with oil and gas in particular is the notice of within the contract, the actual notice that you need. The big question there is, because you have a global pandemic, COVID-19 is literally everywhere. Everyone is talking about it. It's the #1 topic on the news. Can you say that, for example, if you haven't met the specific notice requirements within the contract, you're still sort of constructively haven't given that notice anyway because everyone is so aware of this question? And that is something I'm very interested to see if it's an argument that's going to fly in any shape and form. But to lead on to the next point, my sort of final issues, and I'll run through them very quickly, is, well, we're talking about these issues, but this is probably going to be in a situation where the companies, either the buyers and the producers or the sellers, or the financial lenders and the producers and the operators, are going to be at loggerheads. Negotiation, mitigation, sort of arbitration, all these kind of like preliminary discussions beforehand have failed. You're probably going to find that there's a lot of steps that are being taken before we reach a decision where these things get into court. And that's what leads me to my next slide, Simon, if you could. So creditworthiness and sort of the financial issues that we're probably going to see. Now, I say that government support for the oil and gas industry is probably going to be likely, but of course that depends on the state. You're going to find a lot of states just are physically incapable of providing the financial support that a lot of these industries need, simply because the state is basically spreading the finance to whoever else needs it the most, you know, particular individual victims, the medical industry, that sort of area. But especially states that you find have production sharing agreements, or states that rely heavily on the oil and gas market, you are probably going to see that there is a sort of trend of government support there. And that might be useful, but that's probably going to cause an issue later on when it comes to the final slide that I'm going to be talking about. So I'll talk about that in a second. The other thing that they're probably going to be considering is financial restructuring, either for the producers themselves, sorry, back one slide, Simon. Either for the financial institutions negotiating with the companies because they have interest in them, or the company itself in order to sort of stay afloat. Producers are definitely, like I've said, going to be, thank you, definitely going to be affected by the oil prices. And as a result of this, more than likely, they're going to be facing default. Now, this might have already happened with some of the smaller companies, but that doesn't mean that this isn't going to be happening, as I said before, later on in the coming months. What more than likely is going to happen is that you're going to have the lenders being faced with two choices. Look, either they're going to exercise their right when the companies start to default, or they get into financial difficulty of some kind, or they're going to probably want to waive that default. Now, obviously, the reason why you might want to waive your default is because this is sort of like a temporary big cash blip. They'll take the losses that they suffer now, and then they'll recover it later on, because the long-term benefits of staying in this sort of relationship with the companies is far more useful than sort of cutting your ties. But things will probably get more complicated, and that's related to what I was just talking about, the government sort of support within the industry. How much government support you get can affect the lender's sort of point of view. If they feel like there is a general surge or attitude to save the industry and these particular companies, they are more likely, obviously, than to waive the right. What they'll probably do in that situation is they'll start amending and extending the agreements there. So they'll start renegotiating. And what will probably happen is, in that sort of situation, your producers who are susceptible to the cash will be at a much weaker position. So lenders will probably try and get a leg up there, not just renegotiating their own terms within that particular agreement, but future terms as well. Why they might, though, choose to exercise their right of default and basically let the business fail there, in particular the oil and gas producers, is one, it can be related to the government support, but two, it'll have everything to do with the particular industry at the time and the politics. And there has been a general move and a general bigger awareness to climate change and alternative sources of fuel. So considering the fact that this market is so volatile, and considering the fact that climate change is becoming an issue that is hotly talked about and hotly debated, you might actually find sorry, I've lost my place. You might actually find that these lenders want to get out of these long-term oil and gas agreements and will use the fact that these companies are in financial trouble as an excuse to sort of move on so that they can then invest in other more technologically interesting areas for the energy market. So when we talk about these legal issues, obviously these are things that are going to have to be fought. You're going to be looking at default provisions within the contract, whether you can leave these, whether they'll be waived, whether they're legally enforceable, how tight they are, how bound these companies are, whether from the financial side or from the producer and operator side. So all of these things will come into play, but they really do depend on the politics. They depend on government initiatives. They depend on the economics in individual states, and then the sort of knock-on effects. But the immediate problems, I suppose, that you can argue, the immediate things that companies at least now will want to consider are things like renegotiating the current contracts that they're really in. And if I can move really, really fast to the last slide. I'm so sorry. I did say I have an issue when it comes to timing. But the final slide. The other sort of thing that you want to consider or take a look and sort of think about when you're looking at the market, when you're looking at the news, is the fact that during slumps in previously for the oil and gas industry, this is a prime time for mergers and acquisitions, for bigger companies to sort of swallow up smaller companies. So when you have larger companies looking at acquiring assets, they tend to look at companies that are in financial difficulty but have a lot of technical or expertise or skill that is worth acquiring, and they do so at a cheaper rate. Part of the problem now with the COVID-19 situation is that, and especially because historically states are aware of this issue, you found that a lot of governments have tightened up sort of general oversight when it comes to foreign investment. And we're worried now that what's going to happen is that these bigger companies that want to acquire all of a sudden, especially if these companies, these smaller companies have taken on government support, whether it's worth them taking over these companies because they might have certain restrictions imposed to them, especially when it comes to what I was talking about, things like restructuring and refinancing your agreements, because they might not be able to do so. So the companies might think they're getting a great deal, take over, and then all of a sudden you might have bigger issues that come into play here financially, not just for the smaller company that was already in trouble, but the bigger company who spent a ton of money trying to get this sort of smaller company and now not being able to do anything to save it. So they'll have to take a loss. So you have all these horrible knock-on effects. So we're not going to see these issues immediately. We're not out of the woods yet. When we talk about the fact that the COVID-19 situation is sort of getting better economically, that the oil and gas industry is recovering, that demand is increasing, and prices are going up. From a legal perspective, the interesting stuff is probably not going to happen for another year or two. And from that, thank you very much. I apologize for taking up my time. You could probably take it out of my questions. And thank you.
Thank you very much, Tabitha. And we're now going to move on to Leah's presentation. And I will hand over to Leah now and get onto your slide, Leah. So.
Okay, thank you, Simon. Hello, everyone. Now, as Simon explained at the beginning, my presentation will consider the impact of COVID-19 on seafarers from an employment rights perspective. Unfortunately, the COVID-19 pandemic came once again to underscore the vulnerable position of seafarers, despite the fact that there have been some significant steps insofar as their employment rights are concerned in the past 10 to 15 years. Next slide, please. So my presentation will be divided into two parts. The first part will provide an overview of the current situation and the main challenges affecting the living and working conditions of seafarers, in particular in light of the provisions of the Maritime Labour Convention. More specifically, I will draw attention to the following issues: crew changes and repatriation, social protection, for example, whether seafarers will be entitled to paid sick leave if they fall ill with COVID-19 while working on board a ship, or if they have to quarantine as a containment measure. Welfare protection, what happens currently and what is going to happen with regard to the seafarers' right to shore leave. Health protection, in particular the right of seafarers to health protection measures, including the provision of disinfectants or personal protective equipment, and the right of seafarers to medical care while working on board a ship. And of course, this list is not exhaustive. There are more of the employment rights of seafarers which have been affected since the beginning of the pandemic. But as the pandemic progresses, I believe that these are the main areas with which we will be more concerned, at least until an effective treatment or a vaccine will be widely available. And particularly as lockdown measures are lifted in various countries and as we start to return in some sort of normality, issues of social protection, welfare protection, and health protection of seafarers working on board ships will be in the spotlight. For example, we recently had many incidents of seafarers getting infected while working on board vessels. And most likely this is the outcome of the relaxation of some of the measures. So it's important to consider these issues. Next slide, please. So having that in mind, the second part will tackle two questions. First, what does the MLC say about the right of seafarers to compensation if they fall ill with COVID-19 while working on board a ship? And that's beyond any paid sick leave that they may be entitled to. Would it be possible, for example, to bring a claim against the ship owner? And the second question, can the MLC offer seafarers alternative remedies in cases where their health and safety is endangered due to inappropriate work processes and the lack of adequate personal protective equipment during the pandemic? Next slide. So starting with crew changes and repatriation. Now, under Regulation 2.5 of the MLC, it is clear that seafarers have a right to be repatriated at no cost to themselves. And according to Standard A 2.5, the first paragraph, seafarers are entitled to repatriation when their employment agreements expire while they're abroad, when the employment agreements are terminated, or when the seafarers are no longer able to carry out their duties. And paragraph 7 of the same standard also prescribes that states shall facilitate the repatriation of seafarers serving on ships which call at their ports or pass through their territorial or internal waters, as well as their replacement on board. Now, since the beginning of the pandemic, seafarers were not able to get relieved from the vessels, mostly due to quarantine measures and travel restrictions, the lack of commercial flights, for example. Now, some temporary measures have been taken by extending seafarers' employment agreements, in many cases even beyond the maximum period of service on board, which is currently 11 months. And it is estimated that at the moment, more than 200,000 seafarers wait to be repatriated. Now, some steps have been taken to facilitate crew changes, and I have listed some of them in the next slide. But as countries start to lift lockdown measures, there is some progress in this area, although it is a rather slow progress. And also it is a progress that gives rise to some new problems, since now it is more than necessary to adhere to some strict health protocols to ensure that seafarers who board vessels do not contract the virus and do not transmit the virus to the rest of the crew. Next slide, please. Now, to ensure the seafarers' swift repatriation and to safeguard seafarers' mental health, the International Maritime Organization, the International Labour Organization, the World Health Organization, and the International Chamber of Shipping have worked collectively with other organizations as well, and they have published a series of recommendations. Starting with the first one, the preliminary recommendations through which the IMO urged states to recognize seafarers as key workers. Now, these recommendations came out sometime in March. The progress has been rather slow since then. About 50 countries have recognized seafarers as key workers. And that happened actually, we reached this number in the past month. So as you can see, the progress has been very, very slow. This was followed by guidelines of the European Commission urging the member states of the European Union to designate ports in their territory where crew changes can be facilitated in a safe manner. And the most recent development, which is the one I would like to draw to your attention, is the recommended framework of protocols for ensuring safe ship crew changes and travel during the pandemic. Now, these protocols are quite detailed. They're about 50 pages, and they include processes that should be followed before boarding a vessel and after disembarking a vessel, processes as to how the seafarers could travel from their home of residence to the port where they're supposed to board the vessel. They also include processes that flag states and port states should follow during this process, and of course, measures that the ship owners should follow in terms of the safety of the crew. They also include some information as to how seafarers should monitor their health before traveling to join a vessel, etc. And we can say a few more things about these protocols in the Q&A session. Now, next slide. Social protection and the seafarers' right to paid sick leave if they fall ill with COVID-19 while working on board, or if they have to quarantine as a precaution. Now, we have Regulation 4.2 of the Maritime Labour Convention. Now, under this regulation, seafarers have a right to material assistance and support from the ship owner with respect to the financial consequences of sickness occurring while they are serving under a seafarers employment agreement or arising from their employment under such agreement. According to Standard A4.2, paragraph 1, the ship owners shall be liable to bear the cost of for seafarers working on their ships in respect of the sickness occurring between the date of commencing duty and the date upon which they are deemed duly repatriated. And according to paragraph 3, in cases where sickness results in incapacity for work, the ship owners shall also be liable to pay full wages as long as the sick seafarer remains on board or until the seafarer has been repatriated, and to pay wages in whole or in part as prescribed by national laws from the time when the seafarer is repatriated until the recovery or until they are able to cash any benefits under national legislation. Now, in this context, seafarers who fall ill with COVID-19 shall be entitled to paid sick leave or sickness benefits as long as they are incapacitated to work, which is most likely to be the case when it comes to COVID-19, because we know that the recovery is if you actually suffer symptoms, the recovery is a long process. But even if you don't suffer symptoms, but you are contract the virus, then you have to self-isolate, and you're not allowed to return to your employment unless you can work from home, something which is not really applicable when it comes to seafarers. So the same should apply in cases of quarantine, when seafarers have to abstain from work for self-isolation and containment reasons. Next slide. Welfare protection and the seafarer's right to short leave under Regulation 2.4, paragraph 2. Seafarers shall be granted short leave to benefit their health and well-being, something which is particularly important for seafarers at the moment, especially since many of them have been on board for prolonged periods. Now, ever since COVID-19 first emerged in late 2019, early 2020, one of the containment measures that most port states adopted was the prohibition or suspension of the seafarer's right to shore leave. Some states adopted a blind ban, meaning that no seafarers were allowed to disembark or use port facilities for the purposes of shore leave, and others adopted a more proportionate approach, allowing seafarers who have been on board for more than 14 days to disembark for shore leave purposes. Now, as many states are lifting their lockdown measures, it is expected also that any restrictions to the right to shore leave will also be eased and will follow this example. However, I think it is equally important to stress the need for some health protection protocols, perhaps similar to those that have been recommended with regard to crew changes, to ensure that seafarers who go ashore do not contract the virus and then transmit it to the rest of the crew. And this is definitely an area which requires particular attention as we move forward, given that the virus is still here, it is still spreading in the community, and given that we can no longer deprive seafarers of their right to shore leave. Next slide. Now, when it comes to health protection, I have given you the relevant regulation. I won't read the whole thing, just some highlighted parts. It is clear that seafarers have a right to adequate measures for the protection of their health and a right to access prompt and adequate medical care. This should be at no cost to the seafarers, and port states are under an obligation to allow seafarers to their territory when there is need of immediate medical care. And most importantly, the regulation clarifies that the standards aimed at providing seafarers with health protection and medical care shall be as comparable as possible to that which is generally available to workers ashore. Now, I think this is a triggering point when it comes to COVID-19, because the living and working conditions on board the ship do not always allow for the same level of protection when it comes to this disease, because we know the most effective measure of protection is physical distance, something which is not always possible when you have to live and work in a confined space. Next slide. Now, since early January, the ILO, together with the IMO, the WHO, the ICS, and the International Maritime Health Association, they have provided information and guidance on the precautions to be taken to minimize risks to seafarers on board ships from the coronavirus. I would like to draw to your attention to the most recent ones. Next slide, please. And this will definitely be the most relevant as the pandemic progresses. Is the COVID-19 related guidelines for ensuring a safe seaboard interface between ship and shore-based personnel. Now, at the early stages of the pandemic, the approach was to avoid as much as possible interface between shore-based personnel and seaboard and seafarers. Now, this cannot continue, at least not in the same level as the countries lift their lockdown measures, and thus we're trying to recommence the economy around the world. So this guidance is of crucial importance. It addresses major concerns and expectations of ship's crews and shore-based personnel, and it adopts a risk-based approach in order to determine the measures that need to be taken to address COVID-19 risks to all personnel involved in this ship-shore interface. And the other one is the recommendations for port and coastal states on the prompt disembarkation of seafarers for medical care ashore during the COVID-19 pandemic. Now, these recommendations were produced in response to some rather unfortunate cases where seafarers who suffered some urgent health issues, which were not really related to COVID-19, were refused access to healthcare facilities ashore. For example, we had a situation where a seafarer suffered a stroke and he was refused access to the territory of a state to receive immediate medical care. And it was only after the International Maritime Organization and the International Labour Organization intervened that he was provided with the necessary medical care. Next slide. So what happens if a seafarer falls ill while with COVID-19 while working on board the ship? What does the MLC say about the rights of seafarers to compensation? Now, I've already talked about Regulation 4.2 with regard to paid sick leave, but are there any other remedies on the hands of the seafarers? Now, if we look at Regulation 4.2, paragraph 2, it recognizes that the right to paid sick leave does not affect any other legal remedies that a seafarer may seek. However, it leaves the matter to national laws and it doesn't elaborate on what these remedies could be. Under English law, for example, a seafarer might seek a remedy in tort. A claim for breach of a statutory duty might be applicable, or a claim in negligence. Now, due to time restrictions, I won't elaborate on that, but I'm happy to discuss these remedies during the Q&A session if there is interest on this issue. But what I would like to discuss now is that these remedies may not always be ideal in the COVID context, because any tort remedies that you might have, or any tort claims that you might have against a ship owner that require a very long judicial process, the remedies available are in most cases retrospective, in the sense that they provide for compensation in cases where seafarers contract the virus and suffer symptoms, but they do not ensure that maritime employers act proactively by taking the necessary precautionary measures to protect the crew. It is thus necessary to explore any other remedies that might be available to seafarers to address an ongoing breach of duty. Next slide. For example, can the MLC offer seafarers alternative remedies in cases where their health and safety is endangered due to inappropriate work processes and the lack of adequate personal protective equipment? Well, it is suggested that seafarers can take advantage of the compliance and enforcement mechanisms under the MLC to seek the immediate relief they need in such circumstances. Next slide. In particular, in Title 5 of the Convention, and most specifically under Standard A 5.1.4 of the MLC, it is provided that if the flag state receives a complaint, then the flag state must take the steps necessary to investigate the matter and ensure that action is taken to remedy any deficiencies found with regard to the living and working conditions on board the vessel. Now, inspectors have the power to require for such deficiencies to be remedied, and they also have the power to prohibit a ship from leaving the port until necessary actions are taken if the deficiencies represent a significant danger to the seafarers' safety and health, something that could be relevant in some COVID situations where the processes followed on board the ship are completely inappropriate. Now, in the context of COVID, two issues might arise. First, seafarers might not feel safe to go up front and raise a complaint. So, of course, the convention itself in paragraph 10 of the same standard provides that inspectors shall treat as confidential the source of any grievance or any complaint, but still this might not be sufficient reassurance for the seafarers on board. So alternatively, seafarers can ensure their anonymity if NGOs or unions file the complaint on behalf of them, something which is provided under the convention as well. And in the context of COVID-19 in particular, the IMO together with the ILO have created a dedicated team, the Seafarers Crisis Action Team, which helps to resolve individual cases. And so that could be another outlet for seafarers who would like to raise their concerns with regard to the processes on board the vessel. Now, the second issue is how the inspections could be carried out safely during the pandemic. Now, in this respect, it is important to note that inspections cannot be prohibited or suspended unless there is a force majeure situation. And in the context of the MLC, a force majeure situation applies only when there is an absolute and material impossibility. Now, this is a very strict test to satisfy, which is highly unlikely to apply when there are some precautionary measures which can be adopted in order to carry out the inspection. And I shall refer you back to the protocol I mentioned earlier with regard to the interface between seafarers and shore-based personnel. This protocol contains detailed provisions as to how these inspections can take place even during the pandemic. Next slide. Of course, this is all about flag state inspections, and they will be relevant if a ship is within the territory of the flag state. But there is also the possibility of port state inspections, and the scope of port state inspection, it is generally much more limited, unless, according to standard A5.2.1, there is a complaint or there are clear grounds for believing that the working and living conditions on the ship do not conform to the requirements of the convention, and especially where the working and living conditions constitute a clear hazard to the safety or health of seafarers. Again, something that could be particularly relevant to the COVID-19 context. Now, in such circumstances, port states have the power to conduct a more detailed inspection, and they have similar powers as the ones awarded to flag state inspectors, basically to ask for a remedy, to rectify any deficiencies on board the vessel, and even prohibit a ship from sailing until these deficiencies have been remedied. So arguably, these processes could help seafarers and provide them with the immediate relief they need in the context of COVID-19 when the measures aboard are not safe enough. So I would leave it here. Thank you very much, and I look forward to your questions at the end of the session.
Thank you very much, Leah. Right, without further ado, I will hand the baton over to Yuri to talk about the issues relating to unmanned vessels and UNCLOS.
Yes, thank you, Simon. If you can already move to the next slide, please. Yeah, so to start off with the question, what are the cargo ships of the future that are being referred to here? In a nutshell, what might loom on the horizon is the possibility of cargo being shipped by vehicles having either no one on board or only a reduced crew. Admittedly, this is a bit of an oversimplification. Because normally a wide spectrum of stages of autonomy is recognized when we do speak about autonomous ships. But I will leave this aspect further aside. And what the introduction of autonomous technology does is it challenges our understanding, which is historically formed, of what a ship actually is, and also what it actually looks like. But another matter is, what are the legal implications of that change from the perspective of international law of the sea? Well, in this presentation, I will focus exclusively on those autonomous vehicles where a master, officer, and crew is not physically on board. And the reason for placing this particular emphasis is that these will be the types of autonomous cargo ships, and ships between quotation marks, which will present most of the international law of the sea questions. Next slide, please. First, a word on the law of the sea framework, as this is going to be the main emphasis of my talk. Well, in a general sense, what international law of the sea does, it divides the seas and oceans into different maritime zones. And what it does in addition, it distributes a broad range of rights and obligations among coastal states, port states, and flag states. Although technically international law of the sea encompasses both customary international law and conventional law, in this presentation, I will exclusively focus on the 1982 Law of the Sea Convention, which is the most elaborate collection of conventional rules of the law of the sea. Just to give some context, it entered into force in 1994, and it has more or less universal participation from states. Next slide, please. So despite that their use is envisaged in the future, it is still very much up in the air whether this is indeed going to happen, because there are different views about their economic benefits. And this is also one of the reasons why the international law of the sea framework actually currently largely lies dormant. Because those autonomous cargo vehicles that are in existence, they do solely operate in one state's territory. And that particular state has also authorized their use. You can, for example, think about Finland, which has designated parts of its internal waters as being dedicated to the use of autonomous cargo vehicles in their testing. Next slide, please, Simon. However, it is when the voyages of autonomous cargo vehicles would start to take on an international character, and by that I mean if they would travel outside a state's territory, being either the internal waters, territorial sea, or archipelagic waters, then international law of the sea will take on a further prominence. And then it will become particularly relevant, and it will also raise a number of issues from the perspective of the Law of the Sea Convention as such. Next slide, please. Well, one issue, and this is essentially the threshold question. Are these vehicles that are being used to the end of transporting goods and that they carry no person on board, are they indeed ships in the sense of the Law of the Sea Convention? So I'm only speaking here about, are they ships in the sense of the Law of the Sea Convention? Well, the importance of ship status is quite fundamental, and this is illustrated by that if they are indeed ships, those parts of the Law of the Sea Convention that deal with international shipping are activated subsequently. And this also includes the different navigational rights and freedoms that ships actually have. And it is only vessels or ships that do have navigational rights and freedoms. So for example, if we talk about the right of innocent passage that would apply within a coastal state's territorial sea, this exclusively applies to a ship. So hence the importance of ship status is highlighted as well. But what underlies questions arising around whether autonomous cargo vehicles are ships is indeed them operating without a master, officer, and crew on board. If you look at the literature, there seems to be a more general trend towards bringing autonomous cargo vehicles under the scope of the Law of the Sea Convention. So they essentially assume that these vehicles are indeed ships in the sense of the Law of the Sea Convention. And at the basis of this view lies their apparent similarities, essentially being threefold. The first one would be essentially would be twofold, in the sense that they have the same function in that they currently ship goods, and secondly, although this is currently not the case, in the future they're meant to be similar in terms of size. The cargo vehicles, the autonomous ones that currently exist, they're all of smaller size. But in the future, those differences are meant to be patched over. Well, what would support the argument further that autonomous cargo vehicles are indeed ships in the Law of the Sea Convention would be if you look at other international shipping conventions, and if you look at the definitions they provide, you can see that there are three constants included within them, in that all these definitions will refer to three different aspects. The first one being a ship has to be man-made. Secondly, it must have the capability to navigate on water. And lastly, it must be used for transportation. And if you apply these criteria to autonomous cargo vehicles, the conclusion would be, yes, they are indeed a ship. However that may be, there is a difficulty with this particular approach, where you essentially compare definitions of different international shipping conventions. And that is that all these definitions have been developed with the particular background of the treaty in mind. So just to give you one example, if you look at the 1973 Convention for the Prevention of Pollution of Ships, it provides the definition of a ship is something that operates in the marine environment. And this would also include air cushion vehicles, floating crafts, and fixed or floating platforms. Quite clearly, this doesn't really help to gain an understanding as to what is meant by a ship under the Law of the Sea Convention, because these would quite clearly be excluded from the definition of a ship. Next slide, please, Simon. Also, if you look at the conclusions reached in the literature where people argue they are indeed ships under the Law of the Sea Convention, if you analyze these conclusions more closely, you will see that a lot of them say these are probably ships in the sense of the Law of the Sea Convention. But what underlies this hesitancy to proclaim autonomous cargo vehicles as ships outright? So there seems to be some hesitation in that regard as well. A difficulty is that if you look at the Law of the Sea Convention, you will not come across any definition of a ship. And of course, this automatically introduces the possibility of having various debates over what is meant by a ship. In relation to autonomous cargo vehicles, this absence of a definition has been argued to enable autonomous cargo vehicles to be brought under the scope of the word ship as is included in the Law of the Sea Convention. Well, other commentators have, however, pointed to that the reason for this lack of definition is entwined with the intention to defer the issue to individual states, and primarily flag states, in the sense that once, for example, a flag state would designate a particular vehicle as a ship, all other states would have to defer to this particular designation. But something seems a bit uneasy with this particular view. And one question that does arise is, would this autonomy be complete, in the sense that whatever label is affixed by a state to a vehicle, does every single other state need to follow that particular designation? I would argue that given that the Law of the Sea Convention does refer to a ship, a minimum threshold is indeed implied. And that particular threshold could be set at that particular vehicle needs to be able to comply with the current international rules and standards, and particularly those applicable to safety at sea. And this is already an issue when it comes to autonomous cargo vehicles, because they are not in their current form able to comply with all these rules and standards. If you take this notion, or if you would agree that a flag state would have more or less complete autonomy, it would also imply, for example, if you have a seaplane, and if a flag state would designate a seaplane as a ship, that all other states would have to follow that designation. And this would even be the case if that particular seaplane would traverse through a coastal state's territorial sea. Well, an alternative explanation can also be raised, and that is that the drafters of the Law of the Sea Convention may have seen no need to actually develop a definition, because at that time, remember, the Law of the Sea Convention entered into force in 1994, was negotiated between 1973 and 1982. At that time, it could not have been realistically foreseen that vessels were going to operate autonomously. You would only have the manned type of vessel. And some support for this view can be drawn from looking at the Law of the Sea Convention as a whole. And if you look at its language, particularly when it comes to flag state obligations, you do see numerous references to a master, officer, and crew. So the implication logically seems to have been, if we're talking about a ship, there must be people on board. Next slide, please. So an important implication of when a flag state attributes nationality to an autonomous ship pursuant to Article 91 of the Law of the Sea Convention, then by that very fact, the flag state takes on a number of obligations. However, several difficulties might arise for the flag state in fulfilling these particular obligations when it comes to autonomous vehicles. For example, if you look at Article 98 of the Law of the Sea Convention, this article embodies in conventional form the obligation to render assistance to persons in peril at sea. But quite clearly, if you apply this obligation to autonomous ships, you run into all sorts of difficulties. And these difficulties are particularly created by their autonomy. How can an autonomous vessel with no one on board actually offer assistance to anyone? Does that lead to the conclusion that the obligation to rescue people at sea would not apply to autonomous vessels? That is one argument that has been made, that because of their specificities, the obligation to render assistance would not apply. On the other side of the spectrum, you have the view that if you would accept that they are ships, then they should be held to the same standard, also when it comes to offering assistance, as normal manned vessels would actually be held to. Arguably, the answer lies more in the middle. Another obligation that might create difficulties is Article 94, paragraph 4 under B, which prescribes that each flag state must ensure that its ships have a properly qualified master, officers, and a crew. This article does not say or a crew. So all these people are presumed to be present on board. So an ordinary reading of this provision, which is required by international or by the rule of treaty interpretation, the conclusion seems more or less inevitable that they ought to be based on board. Also, if you look at the ordinary meaning of an officer, if you look at dictionary definitions, you will find most commonly that it will refer to a person who holds a position of authority on a ship. However, the argument has been raised that when it comes to autonomous ships, you do have a controller on shore. And then the argument has been made that this controller on shore could be considered the master. This raises various issues, but just to name one of them, given that the Law of the Sea Convention speaks of a singular master, how do you transpose this requirement to an onshore controller? It would, for example, imply that there has to be one person on board who carries overall responsibility at all times. So if you want to replicate the situation on shore, you will run into all sorts of difficulties, not least in terms of labor standards. Next slide, please. So put in their proper perspective, arguments that do bring autonomous cargo vehicles within the meaning of ship, or who argue that provisions referring to a master, crew, and officer can be interpreted as to refer to an onshore controller, they are based on what is called a theological approach to treaty interpretation. And just to give you some background to this particular view, when applied to autonomous cargo vehicles, is that bringing them within the scope of the Law of the Sea Convention would be in line with the object and purpose of the Law of the Sea Convention. However, these readings do create a tension, and they create a tension on two different levels. First, and this goes back to what I already mentioned, the Law of the Sea Convention was negotiated at a time when autonomous technology, at least when it came to transporting goods, was completely unforeseen. Secondly, it also does create a tension with the rule of treaty interpretation. And the rule of treaty interpretation is laid down in Article 31 of the Vienna Convention on the Law of Treaties. And this particular rule places emphasis on the intentions of the drafters of a treaty. And this intention is exemplified by the wording of a treaty. And if the wording is clear, that is essentially where the buck would stop. But if this is not the case, it may be possibly supplemented by looking at the circumstances that were present at the conclusion of a treaty. So the theological approach sounds very well in theory, but at the same time, it's not the generally accepted approach to treaty interpretation, because a danger that's inherent in this particular approach is that it largely sets aside the main expression of its drafters, which is exemplified by the text, and rather it puts an emphasis on the underlying goal or aim of a treaty, or better said, its object and purpose. But it might already be difficult to really distill what a treaty's overall purpose and object might be. And this will be particularly the case when a treaty strikes a compromise between various and at times competing interests. And this was quite clearly the case when states were negotiating the Law of the Sea Convention, because the Law of the Sea Convention balances between different interests. For example, those of coastal states and flag states. So for example, if you look at the interests of coastal states, and if you go to the preamble of the Law of the Sea Convention, you will see that their interests are recognized as well. So the emphasis is not exclusively on the interests of flag states and their ability to navigate, for example. So if you zoom in on the right of instant passage, which does apply in a state's territorial sea. Within a territorial sea, the coastal state has sovereignty, but this sovereignty is limited in the sense that foreign flagged ships do have a right of innocent passage. So this is a quite clear example where the interests of coastal states and those of flag states are quite clearly balanced. So this does give rise to the question, what if a coastal state, for example, does not recognize autonomous vehicles as ships, even though the flag state might have designated them as such? Would it then have to defer to the flag state's designation, whatever the circumstances may be, or however the vehicle actually looks like? And this is something that has been suggested, that the flag state designation would be paramount. Every other state has to fall in line when it comes to that particular designation. I want to leave it here because this is a question which is quite interesting, but in the light of time, it's probably one for another day. So thank you for your attention. I'm looking forward to any questions that you might have.
Thank you very much, Yuri. Perhaps I can, there have been there's a few questions on Q&A at the moment, but I'm going to take my chair's privilege and ask each of the panelists a question before we get on to this. The question I'd like to ask you, Yuri, is supposing you do, it is accepted that these autonomous ships are ships, contrary to what you've been arguing. What about the, will port states have the right to exclude them from coming into their ports?
Well, when you're talking about coming into port, you touch on the issue of whether a coastal state or a port state can deny access to particular ships. And coastal states already have that particular ability. They can deny access to vessels, although they are not allowed to do this in a discriminatory way. If they, for example, have certain requirements in terms of ships entering their port, they are allowed to set those particular conditions. So I think if they would set the condition of any vessel that wants to come into port needs to have people present on board, they can certainly do that. And this is tied to the fact that within its territory, a state has sovereignty, and this sovereignty also extends to the possibility to deny access to particular vessels. Does that answer your?
That does. Thank you. It's an interesting thing because I've once mentioned that in some of the discussions about autonomous ships which have been going on in the CMI, I think one delegation referred to that they would be treated as floating bombs, Um, anyway, that's an interesting point. So I'm going to move on to Leah now. Leah, I have a question for you.
Yes.
Yeah, Leah, the question I've got for you is about this crew members staying on board a ship for more than the maximum of 11 months. Do you think that's going to make the ship unseaworthy? Because it's going to be, the crew are going to be pretty tired and.
Well, that could be the case. Because when it comes to seaworthiness, it's not just about the number of crew members that you have on board, but it's also a matter of their ability to work. Actually, I've read something yesterday where they were comparing fatigue with having on board an intoxicated seafarer, and they were saying that fatigue can have similar effects on your ability to perform and work efficiently. So that in my opinion, if for example someone works for more than 11 months, and now we have situations where seafarers work for like 14 months in some cases, that yes could be, if you have many working in this kind of situation, yes, that could create some problems when it comes to the seaworthiness of the vessel, if crew changes cannot start in a proper manner soon.
Of course, I suppose with your contracts, if you've got the Hague or Hague-Bisbee rules applying, you've then got the question of due diligence on the part of the owners. If you can't actually repatriate and get a new crew on, what can you do about it?
Yes, but I think now there are some measures have been taken. For example, with the new BIMCO clause for the crew changes, where it says that ship owners can actually sail to a different port where crew changes can be facilitated instead of the port that they were supposed to go originally, where crew changes are not possible. So that might also affect this due diligence obligation on the part of the ship owners, I suspect.
Can I ask you just one other question? You mentioned about the unfortunate gentleman, or presumably it's a gentleman, who had a stroke and then had difficulty getting medical facilities. Can you name and shame the country which was refusing access?
I can't actually, because it has not been revealed.
Ah, I wonder why.
So I wouldn't reveal it either.
Yeah,
it has
okay.
been revealed, no.
Right, I'm going to ask Tabitha a question now.
I'm here.
Are there any sort of specific pandemic clauses already in existence in the oil and gas industry? I mean, with charter parties, we've got Ebola clauses, and then once coronavirus took hold, BIMCO and Intertanko developed their own clauses. Are there any pre-existing pandemic clauses which you're aware of?
Well, no. Part of the problem with oil and gas anyway is once you start looking into contracts, the big oil companies tend to keep them close to the chest anyway. But when it comes to standard form contracts, they haven't updated them for a while. There were some recent updates prior to the pandemic in a variety of JOAs and drilling contracts, farm out agreements, that sort of thing. I suspect, though, they're going to be coming, definitely. More likely, they're probably going to be relying on the force majeure clauses there and then hoping that they're wide enough to cover pandemics.
Yeah.
So nothing specific yet that I can point to from the standard form contracts, but I'm guessing they're there already in some of the others.
Right, thank you. Now I have got, there's a couple of Q&As here. One of the questions, which is for Yuri, what if the autonomous vessel is being used by the military? Can we consider it a ship under the Law of the Sea Convention?
That's a quite complicated question. In the sense that more generally, when you look at autonomous vehicles, they can be used to a variety of purposes. So not necessarily they have to be used for transporting goods. Indeed, they're also used in the context of military activities, but also, for example, in the context of marine scientific research. to focus on the issue of if they are operated by the military, can they be seen a ship? This particular issue has given rise to essentially opposite views, by people saying that they are indeed ships, others are arguing the contrary. The difficulty is that if you look at the Law of the Sea Convention, there is a definition of a ship to be found, or of a warship in the Law of the Sea Convention. And I think it's Article 29, if I'm not mistaken. And if you look at that particular article, you will see that it quite clearly does presume that there are people on board, because it's indicated that the warship, there must be people under armed discipline on board the warship. So to that extent, you do have an issue, but at the same time, it also goes back to this issue of how do you want to interpret the Law of the Sea Convention? Do you interpret it as a more living instrument? And that is essentially also the argument people are making by bringing autonomous cargo vehicles under the reach of the Law of the Sea Convention. They also argue that to go with the times, you also need to accept that military vehicles or military warships can also be autonomous. But like I said, there's a very clear tension with the definition of a warship, which even clearer presumes there has to be an onboard presence. So the designation is quite important in the sense that if you do indeed have a warship, and a warship can also be a ship on government surface. So even then they would, for example, have immunity. So we're not talking only about the destroyers and the very elaborate warships, but even if they are just on government surface, they would have diplomatic immunity as well. So this designation is important, but at the same time, it is essentially a topic on which I can give another presentation of as long or even longer.
Right, well, that actually conveniently brings me through to the chair's last word, because I'm going to need to bring today's meeting to an end. We've had 3 very interesting presentations and some interesting questions and responses to them, but I think we slightly overrun our allotted time, but that's as may be. I'm going to just I'm going to do my salesman act again, where we are. Just remind you that the 16th annual colloquium, which I think will be extremely interesting, disruptive technologies and the issue of climate change in shipping. It's the 10th to the 11th of September this year. It's an online colloquium, and we've got the Eventbrite thing. If you want to sign up, that's there. We are recording this webinar as we recorded our first one, and that will then be shortly put up on our, I think it's going to go up on our IISTL YouTube channel, which we have, and there's some interesting video discussions there. You can see different rooms of my house, amongst other things. So thank you very much, everybody, for attending. It's been great to have you here, and I will now bring I will ask the marketing people to perhaps to bring the meeting to an end. Thank you.